Good morning, Justice Witt. Thank you. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize, monitoring hearing in CCJ Appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Witt, presiding judge.
Good morning, everybody.
Mr. Justice Anderson.
Good morning, Counsel.
And Madam Justice Rajnath Lee.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please your... Sorry.
Go ahead, Mr. Hughes. Apologies.
My apologies. May it please your honors. Nigel Hughes with Miss Leslie Mendez for the appellants.
As well as Mr. Alistair Jenkins.
Please, my lord, Andrew Marshallek, together with Ms. Samantha Matute and Mr. Greg Chuck for the respondent, Attorney General.
Thank you very much. So we will start now with this compliance hearing. We have gotten reports from both sides. There are some issues that we need to discuss. And let's start with some of what we think were at least undertakings by the government. And one of them was that Professor Solorio, the authority, would get a contract, and we haven't seen that yet. So, Professor Solorio, could you confirm that you did get a contract or not?
Good morning, Judge Witt and Your Excellencies. I do confirm that I have a contract signed now with the government.
Okay. Since when? Could you tell us that?
Oh, it started yesterday. We're looking forward to a really.
Was somebody speaking? I kind of heard somebody speaking. No? Can you hear me okay?
Yes, I can. We can hear you. I can
sorry.
hear you.
1 month ago, I actually signed paperwork with the government.
Okay, well, that's good to know. So that is one thing.
Chair, before you go further,
sure.
May I, with your permission,
of course,
indicate our appreciation to the Government of Belize for following through on this issue. I know on the last occasion, Mr. Marshall had given us his personal undertaking to ensure that the matter was resolved. And I think I speak on behalf of the panel in saying that we are very pleased that this matter was seen through, I assume, with the assistance of Mr. Marshallek, to completion. Thank you, Chair.
Chair, may I as well express my thanks and to ask Professor, for how long is that contract?
Well, the contract now is per complaint. So it's a different kind of contract than the one that we have had in the past. And basically, it gives me the possibility to continue processing individual complaints and basically to continue supporting this process in that capacity, which is what I've been continuing to do.
I follow. Thank you very much.
Thank you. Professor, I think we got a letter from your office on the 15th of September, which was one new complaint in relation to Laguna Village. Can you tell us a little bit more about that, if something has been done?
Yes, Justice Witt. There's a few things about the complaint that I think are important to raise, aside, and they're explained in the letter, but I wanted to give you a little bit of background. This is actually the third complaint that my office receives on the Laguna Village, which is of concern, right? And one thing that you will notice in the letter and also in the information presented, by the complainants, is that we have an ongoing situation of illegal surveying without consultation and consent of the village. I mean, that's one aspect of it that was of particular concern to me and my office. Another thing is that the area at issue is an area preserved for wildlife. You know, it's related to the management and protection of Luja, which I understand is a lagoon and wetland for ecosystems. And also, aside from that, you know, in the process of basically working on this complaint, I received additional information indicating a situation or context of violence and harassment provoked by conflicts with Jameri Grove, which is Namaya, and basically claims, you know, from, you know, the Jameri Grove of basically trespassing Laguna Village's lands, you know, and also committing violence and basically using racially charged language to bully village members, right? So that kind of sums up at least the facts that I have before me. And I just wanted to tell you that a few things that I highlighted in the letter that it would be great to discuss more. One of them is the state did issue one cease and desist order, you know, in regards to one of the third parties that were involved in this complaint. At least it did an oral cease and desist order. The government can confirm whether this actually was formalized, you know, whether this was actually done in writing as well. I did ask the state to please investigate any other allegations of illegal surveying that are coming up in this context, and also the consistent issue that we have seen in complaints in general, you know, of issuing, you know, or allowing illegal surveying, you know, without consultation and consent, you know, with the villages involved. This is something that has been a cross-cutting theme, you know, in most of the complaints that my office has received. So I highlighted that consultation and consent is very critical. The other thing I wanted to tell you that it's critical in this particular scenario is vigilance or extra vigilance when it comes to environmental harm. This is an area protected for wetlands. You know, there is potential environmental degradation. So according to current international law standards, it's very important that environmental impact assessments are made, aside from consultation and consent, that there's that special vigilance over potential environmental harm. And lastly, I do think it's very important to give a close look and to investigate promptly these allegations of violence and harassment related to Jameri Grove, and basically also representatives or third-party actors, you know, that are involved not only in the legal surveying, but also what's happening with the village of Jameri Grove as well. I was very concerned about the information that I saw on that, you know, and consistent conflicts on that. So it continues, Laguna Village continues to be the scenario of very concerning situations, which in my view put in jeopardy the CCJ consent order and its compliance.
Yes. Have you had any information? Did you get any information from the government whether there was some follow-up on your recommendations?
Well, they did send me information before the letter on a verbal cease and desist order that they issued against one of the third parties. I haven't received information from the government after sending the letter on September 15th. Okay. But I would assume, since the government is here, that it would be a good idea for them to brief the court as to whether any follow-up actions have been taken. But it continues to be a very concerning context from what I'm seeing. I have a third complaint on Laguna that my office receives. So for me, that's also a source of concern here.
Yes, thank you. Well, I was, of course, about to ask Mr. Marshall if he can shed some light on this issue. Mr. Marshall?
Yes, Your Honor. There's an ongoing live dispute between Jameri Grove and Laguna as the boundaries, and there has been some confrontation between the third parties. The survey that they refer to, we haven't verified what it is. It certainly doesn't come from the government's end. There are investigations ongoing. There are meetings scheduled for this week. I think one after this meeting today and one tomorrow, to try to get to the bottom of what's happening. But there have been some confrontations on the ground between the respective villages. It's all over the news, even up to this point.
Yes. It seems, I'm not saying that it is so, but it seems that, and I think that the government made some efforts to educate Belizeans on the situation, but it seems that not everybody is aware or convinced of the legal situation that we are talking about, you know, fundamental indigenous rights and so on. Sometimes you get the impression that not everybody wants to accept that they may think that, you know, that the Maya people are going to be privileged or something like that. Can you say something about that?
Yes, there's a full gamut of public reaction out there. There are people who understand, there are people who don't, there are people who oppose and are prepared to criticize not just the order, but the court and the whole proceedings and everything, question everything. It goes the full gamut. We have attempted some communication. We have attempted direct interventions with parties involved. We tried to explain to them. I heard the minister this morning expressing disappointment with the behavior of the people over the recent confrontation because we haven't explained it and asked for comment. To that end, well, as a result of that, further meetings have been scheduled, and a way forward to resolve the boundary dispute is, will have to be formulated and implemented. Both parties are insistent that the lands in question are historically occupied by them. I've asked for maps to get an idea of the extent of the overlap. I have a map of what Yemery Grove says is their village boundaries. I don't think Laguna has finished their auto delimitation process and has determined for themselves the extent of the lands that they've claimed, although they're quite satisfied that it extends well into what Yemery Grove says is theirs. That is where I am up to this morning. The meeting scheduled for the rest of this week to see how best to intervene on this. But yes, we do have a variety of people with a variety of views, and they've expressed them publicly. And it is something we'll have to seek to manage best we can. But the surveys are not being done with government approval, and there was a written cease and desist issued. These things are happening in the face of and notwithstanding those efforts.
Okay. Mr. Hughes or Ms. Mendez, any reaction to this particular point?
May it please, Your Honor, Ms. Mendez has the benefit of proximity and much longer, deeper knowledge. I will yield to her.
Okay, Ms. Mendez.
Yes, thank you. Yes, Your Honors, thank you. Good morning to everyone. I'm hoping you can hear me.
Yes,
we can.
Okay, perfect. It is a very scary situation on the ground right now. We are right now in the process of preparing yet another complaint to the authority because, in fact, there has been a very recent development which happened over the weekend that is now, in fact, the confrontation now has escalated, increasing numbers of in number in terms of the amount of people that are now on Laguna's land, claiming that they have some interest in that land. When we are thinking about this particular situation, Your Honors, I just want to perhaps highlight and for us to always keep in focus that some of the land that is being claimed, Your Honors, it includes the cemetery of the village. It includes some houses where people are currently living, includes residential property. And I say that not for the court to make a determination of whose land it is. That's not what we're here to do. But as we try to understand what is happening, as well as we try to propose a way forward, it's important that we bear those things in mind to understand really where perhaps this can go at the very least. In our view, and I guess this again is what we have been fearing all along. In fact, since there was that pronouncement by Minister Mike Spot, is exactly this situation, that it will continue to escalate, and it will continue to escalate because there's not a proper process in place. From the last time, on the last occasion where this happened, the most recent one, we in fact engaged with the government, and we had sent a framework on behalf of Laguna as to how we can manage the discussions between Emery Grove and Laguna, because nobody here is attempting to say, well, you can't tell me anything, we don't need to engage in any conversation with you. It's obvious that there is a dispute, it's a concerning dispute. It's getting scarier by the day. And so we have to speak to one another. But unfortunately, there's a reluctance on the government, to put it bluntly, to engage with anything that involves the appellants in particular. And so that framework was never responded to. We never got any reaction from the government. So now we're here with yet now even graver risk of violence. And I think it was about 80 to 100 people now on the property over the weekend. Also with machetes, taking over lands. It was certainly a very aggressive and hostile situation. Like I said, we are preparing, and we are investigating. Obviously, we are investigating. I can tell you, at least from what we've seen and what the media has seen, what Belize has seen, there were also participants that were not from Emery Grove that were also part of this confrontation.
Ms. Mendez,
so it's getting very sprawled. Mm-hmm.
Can you hear me okay?
Yes.
Can you tell me, or tell us please, in a nutshell,
yes,
the basic elements of the process or the framework that you had recommended? Very briefly.
The basics, Your Honor, is one, the discussions were about the contesting claim. So in that framework, we set out that the government would act as a facilitator, would provide its good officers for the parties specifically to be speaking about the dispute. At the time, what was proposed was a context in which both parties would be speaking to one another. Meaning in the same room. I don't know that that's really feasible at this point in time, but I think that if we amend some of the approach to that framework, where the Emery Grove can communicate its claim, as well as
hello. So you are saying then that you still want the government to facilitate the process through the use of its good offices, but the exact mechanics as to how that is done will have to be changed. What change are you proposing now?
The change that we are proposing now, Your Honor, so I think you're putting me a little bit on the spot, because like I said, we are investigating. The only thing that has come up at this point is that we don't consider it feasible for the parties to be in the same room. But perhaps what can work is that independently, the parties can be talking to the relevant authorities in presenting the context of their claim, so that at the very least, some workable interim measures can be put in place while there is some other process that will determine definitively whose land is
so
it.
do you know who the relevant authorities are that the parties will be speaking to independently?
At this point, we have we had proposed the Chief Executive Officer of the Ministry of Indigenous Peoples Affairs, the Commissioner of the Office of the Indigenous Peoples Affairs, the Minister of Natural Resources in particular, and the Commissioner of Police.
Or their designates, I imagine.
And the Commissioner of Lands, yes, or their designates, as well as the Commissioner of Lands, Your Honors.
May I ask, through the chairman, of Mr. Marshallek, whether that is feasible as far as his side is concerned?
That meeting is scheduled for Thursday. Sorry?
They are asking next week. We have a meeting.
Yes, we have a meeting Thursday with all those respective ministers, and they asked for a meeting with the group the following Thursday.
And that meeting is at both sides, Amerigrove and Laguna.
For next week, Thursday. I'm being told the meeting tomorrow is both parties.
Okay, then
I'd like to say that I don't think it's an issue of process. It's not about how we can bring the parties together and have them talk. It's that there are no principles established on which the underlying dispute can properly be resolved. At that discussion, we have the map from Amerigrove insisting that historically these what have been occupied by them. And we have very clear statements from Laguna that they expect the government to take these people off to assert and respect their claim to the property. The issue is, how do you resolve that? And what are the principles that are to be applied in resolving that? And that is the real problem. So it's not about willingness to meet or putting everybody in a room. We can do that. The thing is, we'll come out that room with the same problem as we did months ago. And we're no closer to establishing the principles on which those decisions will have to be made. In fact,
Mr. Marshall, could I ask this though? I know you're not through with your
yes.
comments, but is it that the level of violence, there can be some agreement on de-escalating that violence? At least that should happen. And in the
Yes.
meantime, there can be then good faith discussions and you all can look for a way forward. It appears to me once the violence or threat of violence remains, that is where it gets very difficult to come to any, not even to accept a process.
Well, the threat of violence will be contained because the Minister of National Security is involved. Steps will be taken to contain that. I have little doubt about that. So we had already spoken to the parties last time there was a flare-up and asked for calm and asked them to understand and respect the process that was ongoing. And of course, that hasn't worked. So in terms of maintaining the peace, some more effective step will have to be taken to ensure that there's no violence on the ground. I don't think there's an issue with that. As I said, I think the real issue is confronting the heart of the dispute and deciding how to resolve it, because the same dispute keeps coming up and rearing its head. And fundamentally, you have Amerigrove insisting that its village boundaries are in one place, and Laguna asserting not only a claim, but making definitive statements like trespass, like using language that suggests that it's a foregone conclusion what the boundaries are. And those just seek to inflame rather than to pacify. But at the end of the day, some principles need to be established. And we thought that moving the policy forward with dispatch was the way to go. But given what has happened, I think some interim measure will have to now be considered because that process is taking its time.
So what are you thinking of, an interim measure?
Yeah, some interim arrangement to hold the ring while to allow the process to go forward. But as I said, we've scheduled a meeting for tomorrow to discuss the terms of that, and then the meeting next week to see how we can get something that both sides can work with in place. Otherwise, the government will have to impose something.
Yes, because it's clear that violence is unacceptable.
So
Yes.
the principle, what you just mentioned just now about the principles, you talk about the principles by which the boundaries would be delimited,
Established.
established.
Yes, Your Honor. Because at the end of the day, what we have is two people saying the same space they're entitled to.
And you're trying to get them both to agree on those principles. And if they can't agree, then a third party will have to, i.e. the government, will have to say what they are. Am I right?
Yes. And we're trying to respect the consultation process and try to do it in a manner, but at the end of the day, both are unwilling to let go anything.
Yes, well, that's how it is. But, somebody has to govern the country, obviously. And if both sides are warring, then who else is there to govern the situation? So I agree exactly with what my sister was saying, because that's what I was getting at, that if you have a process such as was described by Ms. Mendez, then you de-escalate the violence. And that, of course, is one of the things that you want to do. And as you say, to get the parties together so an agreement can be made on the principles for delimitation. That sounds very much like what you were proposing, Ms. Mendez. Are you not happy with what Mr. Marshall said?
Certainly, Your Honor, we are trying to figure out how to deal with the situation, but I would like to put something, make a comment. In terms, it's still about process. You have to have a mechanism through which the root of the matter will be determined. And it cannot necessarily be one that is imposed by the government. Meaning, what has to be established, in our view at least, is an independent mechanism that will then determine what are the principles by which it will decide on whose land it is, where the boundaries are. At this point, what we know is that Laguna has a legally recognized claim to customary land tenure. Emery Grove cannot say the same. What Emery Grove is claiming essentially is national lands. Emery Grove does not have communal lands, and I don't understand that that's what they're claiming.
Yes, I suspect.
So again,
Ms.
we have
Mendez,
competing. Yes.
Sorry, not to interrupt you, but I think we have a long ways to go, and we're just starting. I don't think there's any dispute about the communal land right. I think the dispute is where it resides in terms of the geographical boundaries. And that is what I gather Mr. Marshall is saying. That is a process which is being suggested for identifying that line. And if the two parties can agree on the principles for its location, fine. If not, then the government will have to impose where the line is. If it is, may I complete? If it is that you are not satisfied with the imposition by the government, then there is a route for challenging that in the courts of Belize. But we cannot. Yes, please go ahead.
Can I also add, my brother, that if Mary Grove is not satisfied with the line, because it touches both sides, they too can go to the court. So it may be that I don't think, Ms. Mendez, you want to put your clients back in the court, because I think you understand the length of time. That's why I would think that this is a matter, can I just use the word mediation very, very broadly, that you would want to accept the principles and move on with it. Thank you, my brother.
Yes, I don't think we're saying anything different, Your Honors. I think that we have accepted, and when I started off my comments on this, is that we need to establish some sort of process. We need to establish a mechanism and the relevant principles by which such a dispute will be determined. I'm sure this will not be the only dispute. Yes, we have the general framework under the DPM, but as we have emphasized already as well to the other side, that we always needed a mechanism through which these types of disputes will be resolved. So I don't think that we're saying anything different. I simply wanted to make the point, or rather the caveat or the reservation, that it's not by imposition of the government per se, but rather through a mechanism where both sides can be heard if it is that mediation does not resolve the issue. That's all. And yes, there is no desire to go back to court.
Okay, and we have firm dates for the meetings that Mr. Marshall spoke about. I assume that if we have not recorded them yet, then Mr. Marshall's office will send to us and to the other side, if they are not aware of them, the firm dates for those meetings. And of course, we'll expect to get a report coming out of those meetings. Thank you, Chair.
Yes, are you aware, Ms. Mendes, of those dates?
Yes, we did get some dates, Your Honor.
Okay.
Very well.
Good. Of course, as we have been saying all along, and everybody understands that, this is not an easy process for many reasons. And certainly the government needs to balance all kinds of interests too. So on the other hand, we need to go forward. We will discuss that a little later. I think last time we mentioned, April 25, that would then we would be in this for 10 years. That would really be a time frame that we need to get to some final conclusion of this whole process. But we will talk about that a little later. Once more, violence is never an option, so that must be clear. And I think that every Belizean needs to accept the legal situation. And that legal situation has been formed by the consent order of the government at the time and the judgment of the court. That's the final decision on this area. That doesn't mean that all details have been now worked out. There's still a lot to be worked out, but that is the situation that needs to be accepted. Full stop. So there are a lot of other points, as Justice Anderson indicated, so we need to speak about that. But we expect that given the urgency of this situation, this particular situation of Laguna Village and the neighboring one, that Jemery Grove, that something has to be worked out. But for the time being, we have two dates. This Thursday, if I'm not mistaken, and next Thursday, yes. Correct? Yes. So that is what we will write down, and then we expect some kind of report about that, because time is really losing us, and we don't want that. We need to go ahead. Good. So that is this particular point. And once more, it must be clear to everyone, this is a situation that we have to work with. Secondly, there are a few points. There is a draft Maya land tenure policy. And I think the appellants have been complaining about a lack of consultation. And also about, I think, some what you would call undertakings by the government about meetings and so forth. So could you go into that a little bit, Ms. Mendes?
Sure, Your Honors. I think the point that I was making, or we were making in the compliance report, was that there has not been much progress from our last hearing with respect to dialogue between the parties and the commitment that was made, where there were very specific steps that we undertook to follow up on. And we did in fact follow up on it, but fundamentally we were not, it doesn't seem like at least the commitment to meet was done with much seriousness. And if I could just very briefly, I think that now more than ever really, or at least the pattern what we've seen is that fundamentally the government sees the appellant's involvement as incidental to this process. If we even look at their report, it's a 10-page report and we are mentioned once, and that is only to say that we have provided our inputs on the policy. But we have also requested responses on the policy. So even if we were not to meet, then could you provide some responses to our communication? So I think that reflects really the extent to which the government considers itself bound to involve the parties to communicate with the appellants. On the consultations of the policy, very briefly, we were only told of the date when it would commence. We were not given a schedule of these meetings, much less invited. We did not get any input on the methodology that these would take. I can say we were present at some of them, but that was only at the invitation of some of the leaders. And it was only then that we learned that the government intends to finalize the legislation, not the policy, but the legislation in 2 months. And that is by the end of December. We have no idea how this legislation will be drafted. We don't know to what extent we'll be involved. So this is a drastic change from where we were at least 2 years ago, where we at least had an idea of how the appellants would be involved. And overall, we just see it as a very rather ad hoc, informal process, a very sprawling process in which the appellants don't quite know what their role is according to the government, if they have any at all. So it really cuts against the spirit of cooperation and mutual understanding that resulted in the consent order. And at least the situation in Emerald Grove, I think, should really prompt us to not try to outmaneuver and outsmart each other, especially something as simple as a meeting. It's really a situation of all hands on deck, and it's really a situation that demands a proper process.
Yes. Well, I think the court has made it clear over and over again. First of all, that the government is, of course, well, actually, the consent order says that the government needs to consult with the Maya people. So it's not limited to one group or the other. On the other hand, that's the second point, the appellants are in this procedure, and so they cannot be ignored. They need to be involved, even maybe even more so than any other group. So that has been the perspective of the court. What I understand is that you feel that maybe there's consultation of other groups, but not so much with your clients, with the appellants. So I need to ask Mr. Marshallek to comment on that, because it will not work if these appellants are totally put aside. And once more, clearly the government is free and is actually obliged to consult with all other Maya groups that are there, but it cannot be to the detriment of these two appellants. Mr. Marshallek?
Yes, Your Honor. Your Honor, we of course accept that they are the appellants and they must be consulted. What happened was that the policy was sent to them first, comments, and they sent some brief comments and some questions, asked some questions. And after that, decision was taken to embark upon wider consultations. And then those wider consultations are in process, they're in train. What is in fact being done is a compilation of all comments and concerns in a huge table to take them into account, including the comments and concerns from the appellants. And then we go back and see how we can find some way to address all of them as best we can. We are still in the process of collecting that data. So no decision has been taken on any of it. It's just understanding what those concerns are and then getting back together and trying to find some way forward. What is happening now, I think, it's just the stage of which those proceedings are, because the consultations have spread out to the 41 villages themselves, and they have been involved. And the villages, when they wish the participation or the assistance of the appellants, have invited them in, and we have no difficulty with that. And they come, so they participate even at the village level in the consultations. So I don't understand why they feel left out of the process. What our concern is that you don't get to dictate the process. And I'm afraid where we are right now is just we've spread the consultations wider, not only Maya villages, also non-Maya villages. So Yemen Grove also gets to have this say. I think they're in the last zone, and Barranco and all the affected villages, non-Maya villages. They all have to have their say, and we intend to take all of it into account as best we can, and to bring those comments back to the appellants. But as I said, we haven't completed that process. I think we've finished a number of zones, and we've set it out in the report, and we've scheduled the remaining zones. It has been taking a lot longer than anticipated, and some villages have indeed asked for more time to consider documents before they meet. And those are things we've sought to accommodate, and it has pushed us off schedule. I don't know where the notion that legislation will be done in 2 months. I would wish that were true, but we're not even close to that. The contents of it have not been settled. We are trying to make the consultations genuine, so decisions have not been taken. The changes to the draft in between the first draft policy and the second were really motivated by the confrontations between Yamaragona and Laguna in the interim, the last one. And what the policy essentially seeks to do is to say, look, we'll issue titles for all those lands in respect of which there are no disputes, and everything else has to go to some dispute resolution mechanism with principles and its framework to be set out in legislation. And we've really gone no further than that. It's just accepting that there are multiple boundary disputes when you look at the map. I think the majority of issues confronting the completion of any implementation of the order has to do with settlement of boundaries because they overlap considerably. So all we've said in relation to that is that we title those pieces for which there are no disputes, and we'll have to see how we resolve all the rest. So I think that's a sensible approach. That was the essence of the change to the terms of the policy. And while we sought to introduce that idea as a possible solution or way forward, because a decision has been taken on it, still consultations, we haven't had any suggestion from the appellants as to how any of these issues, which are really elephants in the room, are to be resolved. All we have is a consistent and persistent insistence that they be magically resolved.
Yes.
So I would love to have what they say or how they say these issues are to be resolved. And in particular, I can state what they are. How do you reconcile the claim to buy a land tenure with the existing land titles that have been issued by the government over the years? One. How do we move demarcation forward, given that only 3 have been completed by way of the art of the delimitation process? And that process has been, well, you're heading into the more contentious areas. I don't know how you're going to get any boundaries resolved by way of art of delimitation. We'll have to move away from that and come up with some other way of dealing with it if we hope to get it done in a timely way. I've had not a single suggestion from them as to how these things are to be resolved or what they would want to see done. All we have is that give us a land. We want to law. We have a consent order, hand it over. Get these people off. They're trespassing. So that's what we face. And we've been measured and tried to take into account all sides before moving. And the consultation process has been broad, has been taking a longer time than anticipated. But we're trying to allow that to develop on its own and offer us some sensible way forward. I must confess that I don't see any, and not a solution. What I see is that a solution will have to be imposed. That's where I see this going if we want to get something done. But we have an overemphasis on process and not a drop of suggestion on how we resolve these issues.
Yes, Ms. Mendes? Any reaction
Yes,
to
Your Honor.
what?
Yes, for sure. It's really not true. It's rather a mischaracterization, at least of what has been our engagement, and I say that with the greatest of respect. We have made suggestions in the past. For instance, what one of the mechanisms is the one that I mentioned earlier. Yes, of course, a decision will have to be imposed if there's no agreement. The point that we're trying to make is that that has to be by some independent mechanism, a tribunal, a body, something, some mechanism that would then impose that decision. That is with respect to third parties, and everybody will have to live with the consequences of that. And that is with respect to the boundary dispute as well. In fact, I think it was in May or a little earlier than that, we had scheduled a meeting to discuss this very same issue because this came up in one of our meetings. But if it is that there's a perception that we don't have any solutions or anything like that, it's because you don't want to meet with us. If this was something that that you wanted us as well, our input, we are certainly here to provide our input. And the point is that we have. In terms of the legislation, I'm glad to hear that that is not now scheduled for December, considering that in our view it would be rushed. But that is something that was represented to the leaders at one of the sessions. Okay, but I'm glad for
Ms. Martinez, I really don't want to interrupt you too much, but could I ask the 2 points put by counsel on the table? Are you saying that you have substantive responses? He mentioned the Mayalan customary title versus the fact that the government has been issuing title to people over the years. How do you reconcile those two things? He mentioned the auto delimitation process and the fact that that is not working. Only 3 villages have been delimited. There are 40 odd to go. And he's suggesting that we may have to move away from auto delimitation. Can we focus on those? And do you have any specific recommendation as to how to deal with those specific problems that he has put forward? And I know a meeting is great, but in the absence of a meeting, can we put it down on paper? What do you recommend in relation to these 2 things?
We can certainly put it down on paper, and we have very quickly, in terms, at least in terms of the competing interest, I guess you can call them, that those are third parties, Your Honors. And what we have recommended is a dispute resolution mechanism. And if you could allow me, I know sometimes it seems as if I speak on and on, but just to make the point that we're not here attempting to dictate. In our last communication, we had questions. We want to understand the policy. How is an inquiry as to what the meaning of the policy is? We trying to dictate what the process will be and what will be in there. So I just wanted to mention that. But certainly we can put those in writing once again.
Would you mind sharing them with the court as well when you do that, when you send them over to the government? If you just copy us, I think that would be useful on those Absolutely. 2 specific points. Yes?
Yes.
Thank you very much.
Yes, because we really have to be more concrete now. And we understand that you want the court to get a tighter grip on this process, but we can only get a tighter grip if we have some more idea about concrete suggestions. And then we'll see how far we can push that. So
certainly, Your Honor, we welcome
yes.
that.
So
Yes.
that is about the draft Maya land tenure policy
So, yeah, just
and the delimitation.
Following on from what the chair said, what time frame do you expect to be able to send something in writing? As you said you may have done it before, so it should be easy, relatively speaking, to send something to the government, copy to the court. When can we expect that?
It's 2 weeks fine, Your Honors. In terms of the Maya customary land policy, I think that's what Justice Vitz just mentioned. We want to just update it with respect to reacting to the recent revision. So that's why the 2 weeks.
Sorry, is that the point about the clash between the customary land interests and the titles issued by government, or your position is that is just a matter for resolution by a third-party tribunal? Is that how you would put it?
That's part of the policy of how it's attempted to be addressed in the policy. So that's why I framed it in that way. But yes, that includes that.
Okay. So 2 weeks, you say?
Yes, Your Honors.
Okay.
If that's
Thank you much.
And you will send it to, of course, and you will send it to the other side and the court. And that might mean that we have to look at it a little closer. But 2 weeks would be fine.
So, Mr. Marshall, you have heard your friend on the other side. She will send you something concrete. You have been crying out for something in the way of concreteness. So we would, of course, want to see what your reaction is. We understand your position that you will consider all views, but we certainly want to hear from you in relation to what the appellants have to say in resolving those 2 points.
Yeah, Chair, if
Yes,
I may
certainly.
add, yes, but it would appear to me that both sides seem to be thinking along the same lines, which is that those disputes with third parties over boundaries should go to some tribunal or some other adjudicator, third party, and come to a resolution on those matters. So it does appear to me that they are thinking in the same direction about those matters. And so Mr. Marshallek has been looking for a formula, a process to proceed to put, as I understand it, very thorny issues into some sort of method in which those matters can be resolved. And the thinking, as I understand it, is if that can happen, that would be an excellent thing. And as we think about that, Chair, tomorrow there will be a meeting on one of those.
Yes.
That it would be important that there can be an understanding and a discussion that this is a possible way forward. I believe, Mr. Marshak, that is what you've been looking for.
Yes, and when I say, and I'll put this out there because it's an idea that I'll pass around at meeting, is some interim, possibly some interim piece of legislation to give a basis to those resolutions and that mechanism. Because we can't have these kinds of disputes flaring up while we try to iron out the niceties of the policy and the legislation.
Okay.
Yes. So anyway, we expect then a reaction from your side on the proposals by the appellants, maybe in another 2 weeks from there, so that we will have something more concrete in a month's time. And
now, when you say, I'm sorry, Chair.
Sure. So that if we have something more concrete, then we can consider what the next step would be.
When you say interim legislation, Mr. Marshall, what exactly are you thinking of?
I haven't fleshed it out. I'm thinking about some law that establishes a tribunal and sets out some principles for determining the disputes for these things, for reports to be made and some formal decisions to be taken.
There would
So
be
everything would then be frozen in place whilst the tribunal is considering the various claims made by the contesting parties. Am I right?
Yes, something like that. Yes. As I said, it's just an idea. I tossed it out as for my friend to consider, because what I think is that the situations on the ground won't wait for us to iron out everything as nicely as we would like to. So we need something that provides law and order in the interim.
So when
Mr.
the
Bartlett, I take
appellants send, I'm sorry, my sister, when the appellants send you their proposal, I assume if it does not include what you have said, then yours could be a counter proposal, if you will, in terms of what the legislation could look like, which could be instituted to attempt to provide a sort of interim or temporary solution. I'm just trying to make sure I'm following you.
Yes, and as I've indicated, we're meeting to discuss tomorrow, so it's just an idea. I just tossed it out so that she can have that in her contemplations as well.
Yes, thank you. Sorry, Justice
Mr.
Reifenstein.
No, that's fine, my brother. Mr. Marshall, very interesting. I'm just thinking, the question of the jurisdiction and powers of that tribunal would be something that would have to be fleshed out. Of course, it would be for all of us to recognize that the tribunal, much like a court, will not sit and do this in a week or a month. That some of these matters are thorny and long-standing and will take some time to resolve. So there has to be, in our minds, at least, Mr. Marshall, like I'm thinking that the other processes then should be proceeding, despite hiving off then the boundary disputes, if I may refer to them as that, to some tribunal. I don't know how you're thinking. I know you've said you've just put it out, but we would have to bear many things in mind, I imagine.
Yes, from a practical matter, and this is the change to the policy that we have put out. You issue titles for the portions of or the areas in respect of which there's no dispute. So the process for doing that still needs to be ironed out, and so we proceed with all of that to get that done. What I'm trying to do is exactly as your leadership, your honor has indicated, to hive off the dispute so it doesn't impede progress on the overall issue, and put them down their own path to resolution. So that's my thought. As to the details and the mechanics, we haven't fleshed them out. As I said, we put it on the table as a policy consideration for everybody to comment on. But from a practical perspective, I don't really see us getting far if we don't hive off the disputes.
Okay. May I suggest a 5-minute break, and then we can continue. So if you don't mind, we'll close camera and mic, and we will be back 5 minutes past 12. That will be 5 minutes past 10 in Belize.
Obliged.
Thank you, Chair.
Judges, yes, and counsel is here. Go ahead, Judge. Thank you.
Good. Okay, we took some time to discuss what has been brought up to now. There are only a few little points that we want to touch on now, and then try to get to more concrete steps. We have discussed the situation around Laguna Village. We have dealt with the draft Maya land tenure policy. In that respect, there is one other issue that was brought up by the appellants, that there were supposed to be constitutional amendments and legislative amendments in the draft policy. Can you say something about that, Ms. Mendes?
Oh, yes, Your Honors, thank you. That was a question that we had posed to the other side where we wanted to obtain some clarity. There are two provisions in the policy right now that provide for or propose constitutional amendments, but the way in which those amendments are framed is specifically one, to limit the financial consequences in the implementation of the policy. We're not sure as to what is being proposed, what are the financial consequences envisaged there. And another provision speaks to constitutional amendments to limit the rights that have been recognized by the consent order and to limit or reduce the right to seek and obtain a remedy for the breaches of these rights. So we have in our written correspondence to the other side asked what precisely does this mean, and if we are understanding or interpreting these sections correctly, meaning that what is being proposed is some constitutional amendment that would deprive their right to remedy in the event that it's breached. We also asked these during the consultations, and I cannot say that we were able to get clear responses. In fact, the commissioner said that they would be forthcoming.
Yes, Mr. Marshall, can you say something about this?
Sure, yeah. The concern was that the implementation of the policy in a fair way would result in, or could possibly result in, liability for compensation to be paid to one party or another. There's a recent decision of the Court of Appeal which has confirmed our thinking, which was that Maya land tenure cannot subsist alongside titles that have already been issued. And in that case where tenure is claimed in respect of land, in respect of which a title has been issued by the government, the question becomes whether that land has to be retaken and given to the Maya people, or whether the customary tenure needs to be extinguished and the title upheld. Either way, you have financial consequences. And because we have not been clear in defining these things or the effect of it, the best that could be said was that if necessary, and as necessary, constitutional changes would also be considered at the time to try to limit the financial consequences of implementation of policy. Because we envision that that those claims to compensation can be quite substantial.
Okay, but that is in a very rough way formulated. It's not something very concrete yet.
No, it's not. It's just an idea. It's a consultation. It's an idea put forward for consultation. So we're not able to say precisely what it means because the policy itself hasn't been settled.
Yes.
But it's the idea that however the policy is settled, there might be significant financial consequences to the government, and there might be need for some constitutional change to try to limit that to the extent that even that is possible.
Yes. Okay, but well, what you are trying to do is balance all these interests that uh, that contradict each other, so to speak.
Yes.
And at the same time, that was our impression that if there is any amendment to the Constitution, that may also mean that you will lay down a foundation for these communal property rights in the Constitution.
Well, it can go both ways. Yes.
Yeah.
Yes. Yes. Because once it's defined, then it forms the foundation for both communal and non-communal. It's just the flip side. One's the flip side of the other.
Yeah. Okay. Well, I think we leave this point at this for now, and see how this develops further. There's one other point that we wanted to discuss, which was the revised roadmap. I already mentioned that there must be some completion date of this whole process. In April 2025, we will be working on this for 10 years. We think that is a kind of a date that we should focus on, everybody should focus on, because it cannot continue indefinitely. And that would have some consequences for, I suppose, the revised roadmap and the timelines in there. Could you say something about that, Mr. Marshall?
Yes, Your Honor. I've been trying to get a handle on the date for the consultation process to be completed for the policy. And the way it's looking is that, and I'll ask my friend, I think it might need, the consultations might need another month or so. Once the consultations process is finished, we can proceed to drafting. And that, if the process works the way we contemplate and is effective to clarify some of these issues for us, we can move to drafting more quickly. But there's still a lot of gray areas that need to be nailed down, and we can't really draft anything if we don't have some consensus or some decision made in relation to them. So the process is itself important, and I think so too are the consultations with as the Emerald Grove dispute shows, with the non-Mayan villages. We need to get their concerns on record and dealt with, and then we proceed to drafting. So we're looking at least another month for the consultations. I know some villages have asked for more time. If we allow that time, you're probably looking at another 2 months of consultations. And then we go straight to drafting. Assuming we're clear on what comes out of the consultation, I think that will assist in speeding up the drafting. I think we may be able to have a draft by April 2025. 24, sorry.
Okay, well, so
I'm glad you caught that error, Mr. Marshall, because
yeah.
Remember, we are trying to get legislative and the constitutional adjustments next year,
right. Yes.
2024, because unless we do that, we're not going to meet the April 2025 deadline, and we really want
right.
to do that.
Yes.
Yes. Sir, Mr. Chair, I'm sure you're going to call on Ms. Mendez or Mr. Hughes to respond to.
Sure.
What was said.
Ms. Mendez?
I'm just wondering if we will be able to know what that process looks like in terms of the drafting, and to what extent does the government intend to involve the participation of the appellants? In terms of the roadmap, I think also, is the roadmap, the more recent roadmap still applicable? Because we're speaking about a roadmap, but it doesn't seem that we are also following it. So what are the plans in terms of communicating that roadmap to us and developing it with us, in fact?
Mr. Marshall?
The existing roadmap has been, none of the timelines are current on it. and they all need to be pushed back. We can have a proposal with some revised timelines, I think within the next week, sent forward. I want to try to be realistic with the dates.
Yes, please.
Because I don't think the dates that were put in them originally were in fact realistic with what we found on the ground. So I can only undertake to have a revised roadmap submitted in light of what we found and our new thinking as to the way forward. We can do that within the next week.
Yeah, Mr. Marshall, I think Ms. Mendez raised a fundamental point, though, the other one, which is, can you indicate the process by which the appellants will be involved in the drafting? I think earlier when you spoke about the consultation, something you said, which I thought I heard, was that the government intended to get back to the appellants once all of the comments, queries, etc., had been elicited from the various stakeholders, which I thought was fantastic.
Yes.
So I hope I heard you right on that. And now she's asking another question, which is, once that process has been completed, what plans do you have to involve the appellants in the question of the drafting of the legislation, amendment to the Constitution, if that's necessary?
Yes, we haven't really made any decisions on that. We're aware that the old roadmap provided for the appellants to appoint 2 drafters and government to appoint 2 drafters, and these 4 drafts people would get together and draft this legislation. I'm not sure that will work or will produce any result in an expeditious manner. The alternative thinking was to the government produces a draft, passes it to them for consideration, markup, and they pass it back. And it's really a practical concern as to how we get the draft done by April 2024. I don't think the panel works. As I said, no firm decision has been taken on it. That's why nothing has been offered on it, because we haven't really reached that bridge.
I think we accept that you meaning the government, will decide, what legislation goes forward to Parliament. Clearly, you're the one who must do that. But are you sure that some kind of panel or commission or some advisory body which advises now on the legislation and the legislative provisions would not be helpful? And, you obviously will take into consideration what comes out of that body, if there's such a body. And I believe that if there was such a body, then obviously the appellants would you would have thought, be entitled to a seat on such a body. Wouldn't that be helpful?
Well, the body that decides what decision will go up is Cabinet Ministerial Subcommittee that has been established. So they will be the ones to approve the draft and to see what gets submitted to Parliament. And of course, the consultations with the appellant would happen before the draft hits them. But if there's any chance of the draft going forward, it kind of also have to close the information. Their concerns also have to be addressed. Otherwise, it's going to get stuck right there.
No, I'm with you, Senior. I understand you. All I'm saying is that just trying to react to Council's concerns about the way in which the process develops and how they are involved in it. I'm just trying to find a point of intervention where they can make their views known to the government. And
yes,
yeah, as long as there's that point of intervention, that is fine. I think that is what Ms. Mendez is interested in.
Let us put forward, as I said, we haven't decided. There was just an initial impression that the panel approach to drafting would be too cumbersome and would not move with the dispatch that we expect. So that another way of doing it might be better. But whichever way is conceived of, it will involve the appellants having their input on it and giving them adequate opportunity to deal with it. So can I propose a way forward together with the roadmap in 1 week so that those involved in decision making directly can offer their views on it. I mean, on the government side.
Sure. So you would offer that to whom? To the government within a week or to us within a week?
To Ms. Mendes within a week in the form of the revised roadmap, which is where there was some description of the process before.
Okay.
So what we'll do is change it, the dates, and also indicate along with the dates the way we think it should go.
Okay. We're going to hold you to that, Council. So if you say within a week,
yes.
within a week, okay.
Good. Okay, I think we discussed the points that we wanted to discuss. Is there anything else at this particular point, Ms. Mendes, that you want to point out?
Yes, Your Honor, it's grateful. I simply wanted to alert my learned senior that based on what he has just communicated to us, I think that the roadmap will also have to change in its substance, not only the timelines, because it doesn't seem that what is being thought of really reflects what is there. Let's take, for example, as to how the legislation will be drafted. There's a whole a framework, there's some steps there that are provided in that roadmap that it doesn't seem that, well, at least that's not what has been represented now, are the thoughts around how that will be developed. And just one last thing with respect to the panel, the idea was to have experts there that would be able to remove the emotion. So at least on our end, we do think that it would be practical, but we would await to look at the roadmap and present our reaction to that.
Okay. Ms. Marshallek, Mr. Marshallek, you want to add something to what you have said?
We've all relied on the experts. The trouble is, the experts will agree on what the term of the draft is, and it will put forward, and that'll be the end of it, because it still needs the approval of the members of parliament, and their concerns still have to be addressed. So what I'm trying what I've contemplated and trying to address is trying to balance that from the very beginning so that the chances of that kind of rejection of the draft are minimized.
Okay. Thank you. I will ask our judicial counsel, Ms. Wyke, to summarize the undertakings or the that we have heard, and then I will ask you if that is correct, and then we will put it down in writing, so that we are going to have a somewhat more tight control of the process. Not to hurry anyone up, but on the other hand, we need to focus. Everybody wants to get this done, I think. And so we want to accelerate that process a little bit. As we have said, we expect that the end point should be somewhere in April 2025. So we have some time, but we need to focus on that now. And so therefore we need some more concrete steps, as has been discussed. Ms. Wyke, could you summarize what you have heard in this respect?
Yes, certainly. Thank you, Chair. Okay, to begin, the government has indicated that 2 meetings are scheduled to discuss the Yamery Grove and Laguna Beach Village boundary dispute. These meetings are scheduled for Thursday, the 5th of October and Thursday, the 12th of October. Mr. Marshallek has also proposed for serious consideration the establishment by the government of a tribunal to resolve boundary disputes involving Mayan villages. The court requests that this issue also be discussed at these meetings. The court has requested that counsel for the respondent, Mr. Marshallek, provide a full report of those meetings, including a report on the proposal, which is to be discussed. And the report of these meetings, the court is requesting that these be provided within 2 weeks of the 12th of October, so that being on or before the 26th of October. The second point, the draft Maya customary land tenure policy. The appellants will send their comments to the government, copying the court, including addressing the following issues that were raised by Mr. Marshallek at this morning's hearing. First, the issue of Maya land customary land title versus the issue of the government issuing title to the lands. And secondly, the auto delimitation process, the suggestion that the process is not working and a suggestion that the parties move away from it. The appellants will send their comments and views on these issues on or before the 18th of October, and the respondent will send their responses to these to the appellant's comments within 2 weeks thereafter, that being on or before the 1st of November 2023. I also heard with regard to the revised roadmap, the proposed revisions, Mr. Marshallek also indicated that he would provide Ms. Mendez with the proposed revisions within 1 week.
I suppose it's asking too much, Mrs. Wyke, for you to display those on the screen, right?
Justice Anderson, what I could do is probably send a an email to the parties after the hearing, if that is okay. Or would you prefer to be
yes, you don't have it in writing now that you could display, because I just wanted to be sure.
Very rough draft, but I can share it, sure.
Yes.
But Mr. Marshall, can you confirm that this was discussed?
Yes, I confirm. The only thing that's been pointed out to me is that the meeting next week, Thursday, is tentative because several ministers of government are supposed to attend and they need to confirm the date. But yes, we will meet next week.
Okay. Ms. Mendez?
Yes, Your Honors.
Okay, well, we will put it in writing so that you have it more concretely before you. What we suggest is that given the shorter timelines now, we will have another hearing at the end of November this year. If I'm not mistaken, I think we identified the 30th of November. Ms. Wyke?
The 29th and the 30th of,
Sorry, the
of November.
29th.
Or the
29th
30th.
or the 30th.
Or, yeah.
So, Ms. Mendez, Mr. Marshallek, any preference for the 29th or the 30th?
Both work for us.
Either is,
yeah.
Both will work?
Either is fine, but I'm being told the 30th now. 30th is preferred from our end.
30th. Okay. So we will have another hearing on the 30th at 11 o'clock Trinidad time, 9 o'clock Belize time. Before that, we will have, of course, the reports filed before us, and then we can see what steps have been made and what further steps need to be made. So this is as far as we get today.
Your Honors?
Yes?
Could we have a date for the compliance report? I think
sure. I think the dates are already mentioned after, what was it, Ms. Wyke, after 2 weeks? I think you mentioned the dates.
Judge, we are asking the parties to send reports on specific issues, but if the parties have to send compliance reports, we would usually like those 2 weeks before the hearing.
Okay. So that would be 2 weeks before the 30th. That would be which? That would be the 16th of November.
Ms. Mendez, did I hear you say that you would also comment on the revised roadmap that Mr. Marshallek would send to you? Or was that just in my imagination?
No, Your Honor, that was not in your imagination. I did mention that I would react to that roadmap when that was sent to us.
So we can comfortably put that into the document that we have. You would do that reaction in with 2 weeks?
2 weeks from
the date
receipt
you
of the
get.
same,
Yes.
certainly, Your Honors.
Thank
And
you.
just to be clear, all of these are to be submitted to the court as well, correct?
Yes.
Great.
Correct. So that we
Thank you.
can get a better sight of what is happening. Okay. Then I think we have discussed everything that we need to discuss. Ms. Mendes, Mr. Marshallek, nothing further to add. Then I thank everybody for being present. Professor Solorio, thank you very much also. And then we will come to the end of this particular session. Madam Deputy Registrar, can you close off?
Certainly. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson, and thank you, Madam Justice Washington. Thank you, Counsel, and thank you, Professor Solorio. And a special thanks to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you. Obliged.
Obliged.